So this is video 2 on model of judicial decision making, and then the 3 Supreme Court decisions that I posted. And I want to walk through the decisions in light of the rules of precedent which constitute the model of judicial decision making that we just went over in the first video. Again, this posting and this video screenshot isn't going to make a great deal of sense, or it won't be very useful unless you first have gone through the decisions. And actually, for Plessy versus Ferguson, I didn't give you the actual Supreme Court decision. I believe I gave you a wiki description. Then I gave you Brown versus Board of Education in the Watson case. These 3 cases deal with a significant constitutional issue, and that is, can a state, be it the state or a division of a state, have some law that requires racial segregation under the Equal Protection Clause of the 14th Amendment? Or stated differently, does the Equal Protection Clause of the 14th Amendment prohibit that type of racial segregation? When I say that type, I mean racial segregation required by law. There's a whole other area of racial segregation in public facilities, etc., that has been practiced off and on by private individuals, and Congress has tried to address that, but that's an entirely different matter. Here I'm dealing with a state law that required racial segregation. And the 14th Amendment, along with the 13th and the 15th Amendment, are known as the Civil War Amendments. Their primary function was to declare the end of slavery, and among the cool things then they wanted to do, they being Congress and then the states in the ratification, was to prohibit states from denying people equal protection of the law. What happens, the 14th Amendment, I believe it's around 1868, but by the end of the 1800s, the former Confederate states, you know, the Deep South states, Alabama, etc., and the border states. A border state would be a state that fought for the Confederacy but isn't in the Deep South. Kansas was such a state. Oklahoma was such a state. Those states that fought on the losing side of the Civil War. Some of us think the Civil War is still being fought, but those states that fought on the losing side of the Civil War had laws that reflected a system of apartheid, meaning that they required racial segregation in all possible instances. Sometimes those laws were known as Jim Crow laws. It's kind of interesting. I think Jim Crow was a character in minstrel routines. In a minstrel routine or show was where white men would engage in racist characterization of African Americans by, putting on blackface, etc. It didn't end in the 19th century, by the way. But Jim Crow was a character in those shows, and the character was obviously portrayed in an awful way, and it became widely used as Jim Crow as a derogatory term for African Americans. One example of a Jim Crow law was the Louisiana Separate Car Act of 1890 that required racial segregation in train cars. Homer Plessy was partly black, 1/8 black ancestry, and he deliberately violated the law, and his lawyers defended him by arguing that Louisiana law violated his right, Homer Plessy's right, to equal protection because it discriminated against him because of his race. In the Supreme Court of the United States in 1896, issued its decision in Plessy versus Ferguson. It rejected Plessy's claim, and according to the court, the 14th Amendment established the legal equality of white and black Americans, but did not eliminate all distinctions based upon color. The court cemented the legality of Jim Crow laws by concluding that so long as the racially segregated facilities were equal, they could be racially separate. And after Plessy versus Ferguson, we see this concept known as separate but equal. And by the way, let me tell you that separate but equal is worse than you think. And what do I mean by that? What I mean by that is, because if you stop and think about it, well, not only were the segregated facilities separate, but they weren't equal in all likelihood, and indeed that's so. However, here's why it's worse than you think. Let's assume that you've got one geographical area, a law from the Montgomery, Alabama City Council. If you get that law overturned on the ground that the separate facilities were not equal, the effect is only to change or do away with the practice in that law. But the system of apartheid requiring the races to stay apart still remained strong. And so what really had to happen from most people thought, from certainly a social justice point of view, was that the concept itself of separate but equal had to fall. The problem, of course, is the separate but equal concept was determined by the Supreme Court in Plessy versus Ferguson, and until either the Constitution was amended, and of course it never was in this regard, or the Supreme Court overruled Plessy versus Ferguson, racial segregation in the U.S., at least that racial segregation required by law, was going to be legal. And so we then end up with Brown versus Board of Education, which is a 1954 decision. And I think it's a wonderful case to read in part. I think it comes close to having as much emotion as you could have in a judicial decision. When the case was decided, by the way, the Chief Judge of the Supreme Court, Earl Warren, kind of bird-dogged some of the reluctant judges. He wanted a 9-0 decision. He also wanted a unanimous opinion from the court, which he wrote, and he wanted to write it in language and have the opinion short enough that it could be published in the newspapers of the day and read by people and understood by people who read newspapers. That, of course, was back before cell phones and before the news was just shredded from partisan viewpoints, etc. But in any event, in Brown versus Board of Education, the court, going to the third rule of precedent, overrules Plessy. And was there a compelling reason? And the compelling reason was, the court found, racial segregation in education damaged the hearts and minds of minority children in a way likely to never be undone. That's the court talking. And there's a fascinating aspect of Brown versus Board of Education. In footnote 11, the court refers to a study from Professor Kenneth Clark from Columbia University. Clark and his colleagues had performed a study that then became part of the evidentiary record in the decisions, because Brown versus Board of Education consolidated a number of cases. And the study involved showing dolls to young black school children in the school districts involved in the cases, and the dolls were identical in all aspects except for the color. And the minority kids, with depressing regularity, selected the white doll as reflecting the best traits, which showed that even at that young age, the court said racial segregation was that was required by law was damaging the hearts and minds of kids in a way unlikely to never be undone. And to me, that was the factual basis for the compelling reason not to follow Plessy versus Ferguson. In the third case I posted is not a landmark case, but it illustrates something. And the third case was Watson versus City of Memphis. And that case involved a challenge, and it was decided 9 years after Brown, by the way, regarding racially segregated municipal parks. And what was argued by some after Brown is talking about education and not apartheid in other areas. And in Watson, the court made it clear that the reach of Brown was to all laws that mandated racial segregation. And I think that Watson is kind of an interesting case to consider after Brown. Okay. That ends our discussion of the three Supreme Court decisions as viewed within the three rules of precedent. And as always, if you have any questions, by all means, send me an email. I have some students not in this course who have sent me emails saying, well, I'm confused in this course and you never get back to me. And I looked and what I have is a few emails complaining about their grade. But not any questions that I could have answered. And really, that's, part of my job is to answer your questions. And I love to get them, by the way. Thanks.